Hi, everybody. Thanks for joining us. So, today's case is about alleged lawyer negligence on a real estate transaction. So, what happened here is that the transaction, which was a residential real estate transaction, did not close, and the buyers sued their lawyer for not closing the transaction. They alleged, amongst other things, negligence and breach of fiduciary duty, and the court dismissed the case entirely. So, the lawyer was not found liable, was not found negligent. So let's look into the case in more detail. The buyers alleged several things against the lawyer, but we'll take a look at just two of them. So the first thing is that the property did not have a working furnace, and that the lawyers somehow should have foreseen this being an issue for the financing. So in this case, the mortgage lender did not advance the mortgage funds because the property did not have a working furnace. So the furnace not working was fatal to the buyer's financing, and they blamed their lawyer for that. The lawyer should have known that, apparently, allegedly, and they felt that the lawyer was liable for that. Now, the court did not find that's the case. So this perhaps was something more for the mortgage broker to handle, or maybe even for the clients themselves to bring to the attention of the mortgage broker or to their lender ahead of time. So the lawyer was not found liable for this issue. And I think there's a good lesson right there, because in real estate transaction, uh, lawyers sometimes get blamed for anything that might go wrong, even if it's not their responsibility. So it's good to know that the courts in this case were able to see that this issue was not the lawyer's responsibility, and therefore the lawyer was not liable. So the second thing that we'll take a look at that the buyers alleged is that the lawyer did not advise them to bring in the closing funds, or at least to bring them in on time. They blamed the lawyer for not telling them by what time and date to bring them and how this was critical for the closing. The court actually found that this was not the case and that the lawyer did tell them to bring in the closing funds, but instead one of the buyers, instead of going to the bank, went home and took a nap. And I think there is a lesson right there as well, that for key things like bringing in the closing funds, it's it's good practice to put that in writing, to explain to the client to bring them in by what time and what date, and the consequences that if they don't bring in the funds on time, then the transaction might not close and they could be liable for not closing. And sometimes these things seem common sense, bring in the funds ahead of closing. And sometimes lawyers or clerks tell clients over the phone. But if you as a lawyer or your clerk sees that the client is not bringing in the funds, they're dragging their feet, it's probably a good idea to put that in writing just to be safe, to avoid these kind of invalid allegations or miscommunications. And in this case, the seller refused an extension, so the transaction simply did not close, and that's kind of what caused the litigation at hand. And so some practical takeaways here. And one thing also to mention is that the buyers alleged $4.8 million in damages against the lawyer for failing to close this property, although the property was only it only had a purchase price of $281,000. So you might be scratching your head wondering, well, how could they allege $4.8 million in damages if the house is worth much, much less? Well, apparently most or maybe all of the $4.8 million they were seeking was for loss of use and enjoyment of this property, essentially a loss of lifestyle in having this potential dream home of theirs. And the court found this to be invalid. So number one, the court of course found the lawyer not to be liable. But number two, if the lawyer was liable, the lawyer would not be liable for $4.8 million. So I think that was a interesting lesson there as well, that sometimes clients can allege very exaggerated high amounts or frivolous things against their transactional real estate lawyer, and those things can be unfounded. So yeah, so some key takeaways, as I mentioned, are to document important things, important correspondence with the clients, such as bringing in the closing funds, and especially if they're dragging their feet and there's a risk they won't bring them on time. That's especially then it's especially important to put that in writing. It's important to look out for equipment that's not working and how that can potentially affect the financing. And even though it might not be your responsibility, it might be a good idea to tell the client to look into that if that equipment might affect their financing. So they don't get surprised last minute if it's fatal to their financing. Um, and so, yeah, those are some key lessons from this case. And I hope you found this video useful and interesting. And thanks for watching. I'll see you next time.